versus Ward, and both sides will have 15 minutes, and the appellant will be able to reserve up to 5 minutes if you so choose. And we do have, I'm getting used to it too, so we have to bear with us. We have a clock now that will help you with your presentation to keep track of your time. And you know that we're videotaping. We put on YouTube our oral arguments, and we try to be very careful. I don't see any reason why necessarily referring to children, but this is a domestic relations case, so I just want to make sure and tell you that if you do refer to a child, please just refer to them as daughter or son or child or by their initials or something. Okay? Are we ready to proceed?
That's right.
All right. Let me begin. And just tell me if you want to stay silent.
Yeah, thank you. I would like to reserve 5 minutes of my time for rebuttal.
Sounds good.
May it please the court, I'm Corinne Hoover-6, representing the appellant Jonathan Ward, who is the husband in this instant divorce matter. Husband has raised 3 assignments of error, all related to substantially the same finding of the trial court. And that finding is that husband had either $200,000 of cash in property and or the ability to earn about $200,000 a year of income. This case is a pretty standard divorce case, as divorce cases go, and it was a relatively long marriage of 2 people, and they had about 4 teenage children. From 2001 to 2013, husband and wife operated a landscaping business together in the state of Virginia. In 2011, wife left the state of Virginia and moved to Ohio. Husband remained in Virginia operating the landscaping business. During this period of time, of course, the marriage comes to an end and wife files her divorce case here in Summit County, Ohio. When the case proceeded to trial, it was 2017. And at that point in time, husband made a ill-advised decision to represent himself at trial, discharging his counsel right up as the trial was about to begin. The testimony is limited at trial, and certainly my client, certainly could be said my client made some errors in not adequately preserving the record for appeal representing himself. Notwithstanding that issue there, we do believe that there were some errors made by the trial court, and so we are asking this court, of course, to reverse that decision. In regards to the property division, which is our first assignment of error, we have alleged that the trial court abused its discretion in the property division award because it failed to address these statutory factors in 3105.171. The standard for review is an abuse of discretion standard. However, it does, appellate case law has held that at minimum the court must address the findings or the different factors within that statute. The starting point, as this court is well aware, for marital property division is a equal division unless the equal division would be inequitable. Here, the trial court clearly intended to make an equal division of marital property because the court, in its decision, charted out different columns as opposed to husband and wife and had totals that were not totals substantially mirrored one another. However, in that, the trial court did, on husband's column, indicate that husband had about $200,000 of cash. The testimony the court found that supported that finding was wife's claim that while she was the business operator for husband's business, that husband made about $200,000 to $250,000 a year. Furthermore, wife testified that the parties purchased a house of about value about $200,000 in cash. Husband testified likewise that the home was purchased with a cash transaction. Wife's position was that because this cash existed at the time this house was purchased, that I believe her position was that this cash should be imputed as a property item to husband. Husband's position, although not well articulated on the record, was that this money had been spent because the home that they had purchased, where they both agreed the cash went, was in 2011, several years prior to the divorce trial in 2017. Notwithstanding that testimony, the court did find and awarded husband in what we call a fictional $200,000 of property from this cash that was held at some point in time. It is our position that this was an error to the detriment of husband because this $200,000 that had existed went into the house the wife then maintained in Cuyahoga Falls, Ohio, so that wife received $200,000 in actual asset where this fictitious $200,000 awarded to husband's column had already been spent to purchase his home.
You know, this is kind of unusual because, you know, we get obviously weigh the evidence arguments all the time, or, you know, sufficiency. But in looking at the testimony, it just isn't clear. Nobody really, you know, ties it into.
I would agree with you, Your Honor.
And so what do we do about that?
Good question. My position, although husband did not prove that the money was gone, I think that neither did wife. My position is that from anyone's accounts, we knew this cash existed up until they purchased the home. The home was purchased in 2011, and I will tell you, I don't even think the record was so clear on that. We have a property deed, I believe, that needed in as one of the exhibits, and in my kind of self-exploration of the case, was able to determine that that deed was recorded in 2011. So I am putting forth some assumption that that is what happened, because I do agree that the record is not clear. Our position, though, however, is that both of them agree that the home was purchased with this cash. Nobody agrees the cash existed after this time in 2011.
Well, was there really any testimony in regard to that? And I'm not sure, when you say they both agreed that the house was purchased with that cash, I'm not sure that's in that record, is it?
There was some dispute as to what the purchase price was. Husband testified it was $190. Wife testified it was between $180 and $200.
I understand, but I'm saying even with the testimony, though, they just didn't link it up. You know, they say the cash was in the house, and no, it was in this house, no, it was in that house.
I agree.
And then somebody says, we pay cash for the house. They don't say we use this cash to pay for the house.
I agree, and there was some testimony that I can't understand either, so I'm sure that you can, was it in the brick house or was it in the farmhouse? And I agree that I think the record is very unclear. It is our position, however, that the assumption of the trial court that this cash existed at the time of the divorce trial, that that's where the trial court lost its way, because we know for certain wife's house was valued at about $200,000. We have no idea as to where this asset was, and so to impute that as an asset to husband without knowing for certain when that existed or if it was distinguished completely resulted in a completely inequitable division of property. Our other assignments of error are all, again, substantially related to this issue of this $200,000. On top of finding this as a property division matter, the court also imputed income to husband for spousal and child support purposes in the amount of $200,000. The testimony in regards to that was wife testified she did the books for husband from 2001 through 2013, and that she believes they grossed $200,000 to $250,000 during that period of time. Husband offered no testimony whatsoever about an income figure, other than to say he doesn't know what he made in 2017. He had some bank statements. He believes his expenses were what his income was, but there was no evidence outside of that. The parties did, however, file joint tax returns, and on their joint tax returns indicated their income was about $25,000 to $30,000 a year for these several years prior to the filing of the divorce action. And so it would be husband's position that because those were joint returns signed by both parties, that it is now wife's self-serving testimony to say that's inaccurate. He was really making $200,000 to $250,000, and I know that because I was the bookkeeper when she swore under penalty of perjury to IRS that the income was substantially lower.
Well, but you also have, you know, all the indicia of him earning a lot more than $20,000 or $25,000.
You certainly do, Your Honor.
So what, you know, is the trial court allowed to look at that?
I believe they are, yes. I believe they are allowed to look at that. My position is that while the testimony of the standard of living, everything would support income in a family of 6 well beyond a $25,000 to $30,000 level, my argument to this court is that it doesn't necessarily amount to the $200,000 level. The other issue that husband makes here today is that at no point anywhere on the record was there evidence that husband was paid as an employee, but only that husband owned this business. That factor alone, I believe, for child support purposes has to be taken into consideration because the child support guidelines have income criteria on several different lines of those statutory guidelines. The first line is income through wages, and then the following several lines are incomes through self-employment or self-generated income is the language of the statute.
Counsel, you're almost at your
Thank you.
5
The
minutes.
self-generated,
Go ahead.
thank you, Your Honor. The self-generated income, of course, the difference in that would be that self-generated income would be, the statutory factors taken into consideration is that someone would have to pay taxes on top of that and is not already withheld as though they would be as a W-2 employee. So we believe that that alone, as set forth in the child support guidelines, would show error on behalf of the trial court, because had you even taken the $200,000 of income on that self-generated income level, it would have put his income for child support purposes at approximately $134,000 according to the guidelines, which would be significantly different than had the court used the $200,000. Thank you, and I would reserve the remainder of my time.
Thank you.
Good morning.
Good morning.
My name is Adam Morris, and I'm here on behalf of the appellee, Melissa Kiernan. Your Honors, this case is about essentially husband at this point in time attempting to change the record and create a new record. As counsel indicated, he was not represented by his own counsel. He had an opportunity by Judge Cook to obtain counsel and to have counsel at the hearing. He decided not to do that. He had an opportunity to put on testimony, and he decided not to create the record. And now he's here today asking to create a new record. So looking at the assignments of error, and I'll start with assignment of error number 1. This court uses a civil manifest weight of the evidence standard and has to, the appellant has to show that the court clearly lost its way. And the evidence in the record supports the appellee's position that the court did not lose its way. In fact, the only evidence in the record supports the appellee's position that there was this $200,000 in cash and that the court can take it into consideration. Wife testified that there was the $200,000 of cash in Virginia. Husband never refuted that testimony. The only thing husband points to is this testimony on page 158 of the transcript, where they're fighting about whether they're arguing on the record whether the $200,000 is located in the Virginia house or the brick house. But the only testimony in the record is that this $200,000 was in existence. There's no testimony in the record that this $200,000 was used to purchase the Cuyahoga Falls home.
Well, wouldn't that be implied, though, when you're talking about $200,000 in existence, and then the wife says, and you bought the house with cash?
Well,
why are you talking about those two things in the same instance without discriminating between, or distinguishing, I should say, between the two of them? Then?
Yes, Your Honor. And if you look at, actually, if you look at page 159 of the transcript, husband contradicts that own position, where he says, his question is, would it trouble you to know that you can't actually buy a house with cash? So he's saying on the record, I know it's his question, but he's asking her, don't you know that you can't buy a house with cash?
Then didn't she explain how that happened?
Well, she did, but she didn't point to that it was that the money that was in the safe. I mean, there's nothing in the record to suggest that the funds that were located in the safe were used to purchase this home in Cuyahoga Falls. And the court, who was there as the trier of fact, has the ability to determine the credibility of the witnesses and had the ability to determine that husband was not credible and made the finding that this $200,000 was in existence at some point in time and that husband had access to those funds.
Was it wife's position that the $200,000 was still in existence at the time of the divorce?
Your Honor, that's not necessarily clear in the record.
I mean, on any of the filings, the documents, or anything she filed when she was, dividing up, when you have to divide up, obviously, the assets and assess the property settlement.
I believe there was a proposed order that was submitted to the court that the court utilized in preparing the divorce decree. And I believe in the proposed order there was mention of the $200,000.
When the complaint for divorce was filed, was there an affidavit of income and expenses filed as well?
Yes.
Was there $200,000 listed as cash on that affidavit?
I am not. I did not get a chance to review the affidavit of property, so I can't give you a firm answer on that.
How about when there's testimony from the one witness that husband brought in, there's a $60,000 alleged loan to the husband from this individual. Is there anything that touches this availability of cash issue at all in that testimony? Because it's my understanding that that loan happened subsequent to the purchase of the house.
Yes, Your Honor, and I think that the judge stated clearly in her testimony that she just didn't find husband to be credible. She found him to be extremely evasive and didn't find his witness to be credible. There were simple questions asked to him during these proceedings. What's your income? Well, I can't give you my income. When was this case filed? His quote is, and Judge Cook puts it in her entry, the question is, when was this case filed? And he says, it wasn't filed on this date, and he says debatable. So he was extremely evasive throughout these proceedings, and I think Judge Cook just did not find his testimony credible or the credibility of any of his witnesses. Your Honor is talking about the assignment of heir number 2, and this is relating to the spousal support issue. The court did find that the court found that he was underemployed for child support purposes and imputed to him $200,000 for child support purposes. For spousal support, the court did review the 14 factors based upon the evidence was presented. They found that based upon his standard of living, the gifts that he was buying for a wife, the fact that they had $200,000 of cash, they had another house that they paid in cash, they had all these different vehicles and boats and canoes, and they were living a very high standard of living based upon the testimony. The court found that his testimony regarding his income tax returns was not credible, found that the income tax returns were not credible, and therefore said that he has the ability to earn $200,000. Now,
Counsel, let me stop you right there because this is something that's a little confusing to me. You're saying that the judge found that he wasn't credible, that he earned a lot more than he's letting on, basically, right?
yes.
Okay. Well, why would you be imputing anything then? Because that's just a lie then. It's not a matter that he's not earning money and we're saying he can earn more money.
Well, for spousal purposes, she can't say that she's imputing him income, but I think what she says is that based upon their standard of living and based upon wife's testimony that he was earning $200,000 and she was the bookkeeper of the business, that the $200,000 is a reasonable and appropriate number.
Well, in the assignment of error, it talks about imputing income, and then you mentioned imputing income when you started your argument, so that's why I wanted to make sure what we're actually talking about.
Yes, Your Honor. And I apologize if that's confusing, but imputing income, as this court knows, is for child support purposes. For spousal support...
Oh, we're not talking about child support.
Yeah, for spousal support purposes, she went through the 14 factors to determine what was a reasonable, appropriate number.
Okay.
Was that based on, I believe the testimony that wife gave was that he was grossing between $300,000 and $350,000, and then after expenses, the net was $200,000 to $250,000?
Yes, Your Honor.
Okay.
Yes, that was the testimony, was that he was grossing between $300,000 to $350,000, and the net income was $200,000 to $250,000. And the court used the lower range, used $200,000. Your Honor, this.
So, but I'm confused. I'm going back to, you were talking about assignment of error number 2 at that point then?
Yes.
Okay, because her assignment of error, I shouldn't say her, his assignment of error is that the trial court imputed income to him of $200,000. And then, and you mentioned imputing income, so that's why I was getting confused. But go ahead to the, are you going to the third one now?
Yes, Your Honor, I can move on to the third one. I just wanted, just briefly on the spouse court issue, there's case law out there that this court has decided that talks about, it's Kikoski v. Kikoski, it talks about an individual, just like husband, that doesn't provide his income information, and that the court is able to look at the standard of living and determine what his income is without, husband makes the argument in his brief that, oh, well, the court didn't have the information, so how could they even figure out his income? Well, the court has to use all the information they have to do that, and it was on husband to provide that information. So moving on to assignment error number 3, this is the child support assignment, and this is where the court looks at the imputation of income. And the court did make the finding that husband was underemployed and that they were going to impute income to him of $200,000.
How is he underemployed? That's, see, we're getting into my concerns now.
Well, the court, husband's testimony at the trial was that he can't work because he's got medical issues, and that he's not really making that much money, and he's got all these things going on that are preventing him from being able to work. So the court couldn't necessarily say, well, this time he's making $200,000 because he had testimony saying that he was not working and that he's got these medical issues that are affecting his ability to work. So the court
I
found...
thought that was all future,
Right. Yes, Your Honor.
that he wouldn't be able to work in the future, wasn't the court looking at his income at the time of divorce?
Yes, Your Honor. However, at the time of the divorce, he didn't have tax returns done. The court asked for his bank statements, and he basically said, here's what I have, you go through it and figure it out. He told the court, I cannot figure out my income at this time. So the court was left to the job of sitting down and trying to listening to the testimony of wife, which really was the only testimony regarding his income, and determining what his income should be.
I think perhaps, then, she can correct me if I'm wrong, Judge Carr's point is when you say he's making $200,000, that's a finding, it's not an imputation for spousal support, but then also make a finding that he's voluntarily underemployed for child support, and then impute up to $200,000. Those two findings are internally inconsistent and not reconcilable. Thank you.
Because I couldn't get that.
Yes, Your Honor. I believe that was an error in the entry, because under spouse support, she does say his income is $200,000. I believe she should have said his earning abilities are $200,000, not that his income is necessarily $200,000, because the testimony was that previously he was earning $200,000, and that was from 2011 to 2013. I believe that was a minor error in the entry, but the court can read the entry and could determine that she was really trying to say, under the spouse support factors, that his earning abilities are $200,000, just like they said wife's earning abilities are $17,000 at minimum wage, even though she wasn't earning minimum wage at that point in time.
Did they use that $17,000 minimum wage when they made the spousal support calculation as well as the child support calculation, or it just doesn't appear in spousal support, it's not necessary?
I believe the $17,000 was used in the spouse support calculation. Under assignment error number 3, as I was talking about, it's husband's responsibility. It's his responsibility to bring his business expenses, to bring his revenues and his business expenses, and provide that information to the court. And he simply did not do that. And there's areas in the transcript where the judge says, I'm giving you one last chance to provide your information. And he could not give the court an answer on what his income is. She sat down and said, give me your income, tell me what it is. And he could not do that. And for him to come to this court and ask, now he wants to create a record. Now he wants to get a second bite of the apple. Well, the purpose of the proceeding was to get them divorced and to give them finalization, and that was his time to create a record if he wanted to create a record. Your Honors, I'm here for any additional questions that you may have.
I believe there are any. Thank you.
Thank you, Your Honor.
Your time is 4 minutes.
Thank you. When you look at this matter as a whole, the significant factors that I would leave this court with respectively would be that the parties physically separated from one another in 2011. While the record is unclear as to when exactly the Cuyahoga Falls home was purchased, I think the testimony in regards to the child-related issues well establishes that wife moved here to Ohio in 2011, where she resided with the children and husband resided in Virginia. The significance that I find in that is that as far as wife's knowledge of what cash may have been accumulated and what income husband earned or was capable of earning was all limited up until the period of time ending in 2011. From 2011 onward, wife had no knowledge of the business as far as what it was earning. Wife had no knowledge as to husband's role in the business, and wife had no knowledge as to what, if any, cash had accumulated during that time. While wife never said in her testimony she believed that $200,000 had still existed, I will answer the court's question posed to my esteemed colleague here, is that in her financial affidavits filed with the court, she at no time listed $200,000 in cash. And I don't speak from that of knowledge of being involved in that proceeding, but just in reviewing the record and as my role as appellate counsel, knowing nothing other than what my client told me and what the record said for itself. From my review of the record, the only time that wife ever asked the court for a finding of $200,000 of cash as it relates to property division settlement were in her proposed findings of facts and conclusions of law submitted to the court. While certainly there were some errors that my client made at the trial court level in failing to preserve the record or to adequately put before the record information as to his income and assets, it was wife's burden of proof. It was her divorce action filed here. And just as husband did not do himself any favors in his own testimony on those factors, I believe the record also shows that neither did wife. And that wife failed as the prosecutor of the case in establishing income for husband after the period of time of 2011 when they physically separated, which was again several years prior to the divorce action which was heard in 2017. To the point of imputing income, I would certainly, in answering questions posed to Attorney Morris, would say that it's probably minor as well in referring to this as imputed income throughout these proceedings. I think much of that is probably domestic relation lawyer talk that doesn't translate well into what the statute actually says. And what the statute actually says is that relative earning ability of the parties. And so I believe that that is the error that the court made, is that the court held that it was my client's relative earning ability that was at $200,000. And I believe that the record does not support that, again, for the reason But the only testimony on that fact, being wife's testimony, that wife was without knowledge after 2011 to opine on the earning ability because she had no knowledge as to what husband was doing. Husband's testimony was that he was working, he couldn't tell you what he was making, he hadn't filed tax returns, but that he did have some current health issues. On the record, he mentions a couple surgeries that were up and coming, as well as, I believe, his age, that he indicated that he did not believe he would be able to continue operating his business as he had in the past. I have nothing further.
Well, thank you so much for your presentation.
Thank you.
Thank you both for your arguments. And the court will take the matter under advisement and issue a written opinion, which will be sent to the parties as well as released on our website and the Supreme Court website. So thank you very much. And the court will be adjourned until